Okay, we have with us today Elliot Teitelbaum, who is in charge of operations, the head of operations. He actually probably knows a lot more about LLCs than I do. He's been doing this for a while. He was from the original starters of the company, and he'll be filtering questions. We'll have Q&A at the end, but if there's any questions that are important for the slide that we're on, then Elliot will ask, and so you can just type your questions on the side, and he'll send it to me. My goals today are, first of all, to try to stay awake because I don't usually stay awake during webinars, not as a presenter and not as a participant. So I'm going to try to stay awake because that would be quite disastrous. To that end, I try to entertain myself. So even if you guys don't appreciate it, just know it's for the greater good. The second thing is to keep you guys awake, hopefully. And the third thing is to give you guys a feel, more than get into the details. We will get into a lot of details, but I want to give you a feel for the CTA so you'll understand what it's all about. And whether you remember the details or not, you'll have an understanding of how to deal with each question about the CTA. Okay, so without further ado, let's just jump into the slides. Okay, the agenda. The agenda, first we'll talk a little bit about the background of the CTA. We'll talk about which businesses need a file and some exempt entities. Then we'll talk about who needs to be listed on the filing. And then we'll talk about the information that's required on each filing and what the deadlines are. And lastly, we'll talk about the big court decision from a week and a half ago, where the federal court decided, they ruled that it was unconstitutional. But as you'll see, not a lot changed. Things may change, but it's unlikely. But at this point, not much has changed for 99.9% of the people who would have to follow. So a little background. Let's just get some of the terminology straight because people call it the CTA, people call it BOI report, some people call it the FinCEN report. So let's just break it down to what each of these things actually are. The CTA is what we refer to as the Corporate Transparency Act. That's a law that was passed by Congress in 2021, and it was set to go into effect January 1st, 2024, which it did. And that's the name of the law in general. What the law says you have to do is file a beneficial ownership information report. That's what we call, that's the report, that's the actual filing. You file it with the federal government, and that we call the BOI. Some people call it the BOIR for the Beneficial Ownership Information Report. Some people just call it the BOI. Some people call it the BOI report. And then there's FinCEN. FinCEN is the Financial Crimes Enforcement Network. They're a part of the Treasury Department, and they're responsible for enforcing the Corporate Transparency Act. So what's the CTA all about? The CTA is trying to help combat money laundering, terrorism financing, corruption, and tax fraud. You'll see the picture behind, if you guys remember, back in the day, I don't know if they still have it, in the streets of New York, you'd have a guy sitting there with 3 shells and a little ball, and he would put the ball under one of the shells, and he would move his hands really quick, and you would have to figure out which shell the ball is under. And a few people would win, but those guys were set up because nobody could win these guys. So after they were set up and they won, everybody would step up thinking that they're going to win. And of course, they would lose and lose all their money. This is a game that the federal government hates. There are a lot of shell companies out there, and there's a little bully with the money going back and forth between all the shell companies and the federal government. Because of the way the states handle the LLC filings, they can't always trace the money trail. They're not good losers. They don't like to lose. So they came up with the CTA Act, which, while the states are willing to look away from ownership and all the details when you form an LLC, the federal government wants to know everything and everyone behind every LLC. And we'll get to the exact information that they want to know further in the presentation. So which businesses need to file a BOI and which are exempt? So what they call it is a reporting company. If you're a reporting company, you have to file. If you're not a non-reporting company, you don't have to file. And a reporting company is defined as any entity that's formed by a filing with the Secretary of State in any of the 50 states and Indian tribal regions, Puerto Rico, any part of the US. So those entities that are considered reporting companies that are formed through the Secretary of State are typically corporation, an LLC, a limited partnership, and there's also foreign companies that are registered to do business in the US. So a foreign company wants to do business in the US and registers with a particular Secretary of State would have to file, and then they become liable to file the BOI. The ones who don't have to file are a sole proprietorship. Anybody could open up a business under his own name anytime he wants. There's obviously reasons why you don't want to do that, because especially because you would have personal liability. There's general partnerships, which are even a bigger disaster for personal liability, because now you're responsible for your partner's um, actions. And most trusts, except for a few particular trusts, like a Delaware statutory trust, most trusts are just documents that you write up by yourself. You put it in your drawer. You don't have to file with the Secretary of State. And therefore, they don't have to report and they don't have to file a BOIR with the federal government. So in the CTA, there's 23 exemptions of companies that don't have to file. But the truth is, there are no exemptions. The reason why these 23 types of entities are exempt are because they already have far more oversight, and the government knows much more about them than the BOI will tell them. They're typically companies, and we'll show you a list of all those the 23 exemptions. But just to give you an idea, those are companies that are already regulated by the SEC, the Investment Company Act, the Federal Credit Union Act, and so on and so forth. We don't have to go through all these acts, but and these are serious filings, not just a BOI, and you can't hide from the government, so there's no issue with tracing the money. The exempt entities, those would include, so there are 23 of them, as we said, and you can look through the list quickly. We're not going to read them all off, but they're either securities, as we said, accounting companies, insurance companies, commodities companies, public utilities, all entities that are regulated and not just free for anybody to open up without any special license. Okay, the two that we're going to focus on, there's tax exempt entities, which we're not going to get into in this webinar because we assume that most of you are for profit. The two that we're going to focus on now and get into some of the details are large operating companies and inactive entities. So people think that I have conversations like this every day with people. They say, yeah, I have a whole bunch of entities that are inactive, so I don't have to file, right? And these are typically a lot of people when they open up their first LLC, it's wrong, it's not the right thing to do, not the right state, not the right entity, and they end up just shelving it and doing nothing with it. And in their mind, this is inactive. But the government's idea of inactive is not your definition of inactive. And they literally have to be, I mean, not literally, but as an analogy, I would say they're more like an Egyptian mummy where they're dead, buried, and really no life to them, really cold corpses. And there's six clauses that you need to meet, six conditions in order to be inactive. The first one and the most important one, which is where most entities fall, is that they have to have been in existence before January 1st, 2020. If you don't meet that condition or any of the conditions, it doesn't make a difference if you opened it up and 10 minutes later regretted it and didn't open up a bank account, didn't file for it, didn't get a EIN number. It doesn't make a difference. If the entity was formed after January 1st, 2020 and hasn't been dissolved yet, that's called an active entity and you have to file your BOI. Okay, so assuming that your entity was formed before January 1st, 2020, then we get to some of the criteria, which are a little bit more logical, if it's called active or inactive. So the second condition is that it's not engaged in any active business. That's pretty natural, pretty obvious. Now, there's an exception. It can't be owned by any foreign person, not directly, not indirectly, and it doesn't make a difference if it's wholly owned or partially owned. If there's a foreign person involved in the entity, then you have to file the BOI. And a lot of that has to do with international terrorism and pretty much shell companies, which are not active, could have been formed a long time ago and are used for funneling laundered money. The fourth condition is the entity has not experienced any change in ownership for the preceding 12 months. So if in the past 12 months, they look very carefully at the last 12 months and any changes over the past 12 months, as we see also in condition number 5, that any amount of money greater than $1,000 that went through the bank or through the LLC, that was funneled through the LLC, that means that the company is active. And the last condition is that the company doesn't hold any assets whatsoever. So if you meet all these conditions, which again, I don't remember anybody who's met all these six conditions, then you can safely say that you have your LLC, you don't have to dissolve it, and you don't have to file your BOI, and you're exempt with exemption number 23 for being an inactive entity. Elliot, any questions so far? Okay, let's move on to large operating company. Large operating company is defined by 20 full-time employees. There is a law, what's called a full-time employee. I'm not going to quote it, but 20 full-time employees, it has to, I think, believe 30 hours a week for a full month. But whatever the law is, you need 20 full-time employees. And you also need, number two, you need $5 million in gross sales in the United States. So if you have $5 million in gross sales, and that includes some international sales, the international sales don't count for the $5 million. And this $5 million is not what you think you're going to make this year or what you've made so far this year. It has to be filed on a federal income tax from the previous year, which means that there's no such thing as a startup company that can be any entity that was formed this year cannot be exempt from being because it's a large operating company because it didn't file a federal income tax return last year. So by definition, it's not considered a large operating company. The third one is that it has to have a physical office within the United States. So that is what we call a large operating company. So now here's where things get a little complicated. Let's say you have an affiliated group of companies. So let's take, for example, a licensing company. So the licensing company has separated, which is smart move. They separate their intellectual property from from the sales company. So their intellectual property company has, let's say, 7 employees and may not have $5 million in sales. And then they have the licensee of their technology, if that's what it is, and they have 20 employees and they have $5 million in sales. So the question does the licensing company, which is a parent company, that is that exempt because there are 20 employees in its child company? So the rule with affiliated group of companies is that you could consolidate income across the group. So if you have two child companies and each one is $2.5 million in revenue in the United States, and the parent company, let's say, has no revenue, that would be okay. All three companies qualify for having $5 million in gross sales. But you need the other conditions as well. So let's say only the child companies have 20 employees each. They each have 20 employees. So that would mean that while each of them would be exempt from filing because each one has $2.5 million in sales. Together with the group, they have $5 million in sales, and they each have their own 20 employees, so they would be exempt. But the parent company, even though it qualifies as having $5 million in gross sales because of the two child companies, it doesn't qualify for having 20 employees because they themselves don't have 20 employees. So this is where those two conditions are split. The affiliated group works for the revenue, but it doesn't work for the full-time employee. Who needs to be listed? So we have, I would say, I broke it down into three different groups. You can break it down into two groups, but let's look at it as three groups. Beneficial owners. So what does a beneficial owner mean? A beneficial owner means that it has at least 25% of the ownership interest. Now, the question is, what's an ownership interest? So obviously stock or an equity interest is ownership interest. Voting rights count. And we'll see in a minute how we look at voting rights and how we figure out who's a beneficial owner based on voting rights. Let's say you have futures or convertible shares that convert into a 25% ownership interest. Even though you haven't converted it yet, that makes you a 25% ownership interest and makes you a beneficial owner who has to file. Now, again, if there's a put, a call option, or a straddle on 25% of the equity, same story. Which means that even though you can't have more than 4 people owning 25% of a company, you could have an, a large amount of people, a larger amount than 4 people, who are considered beneficial owners for having more than 25% ownership interest. Because you could have 4 people that each have 25% ownership interest. Then you have people who have future convertible rights. You have people who have put all these people. It doesn't make a difference that if it adds up to a lot more than 100, they're all considered owners, beneficial owners, as far as the government, the Corporate Transparency Act is concerned, and they all are. They all have to file on. They have to be listed on the BOI. Okay, so let's try to break this down a little bit more. When it comes to a corporation, you can have one of two things. Either if you have 25% of the total voting rights, or 25% of the ownership interest. It doesn't need to be both. It could be either or. So again, you have more people becoming beneficial ownerships. Let's say they have preferred shares where they only have a small amount of equity interest, but they have a large amount of voting interest. They can be beneficial owners. Now, let's say you can have some really complicated structures that you can't figure out exactly what the total interest is, the total ownership interest is, and therefore you can't figure out who has 25%. So they have a catch-all. The government has a catch-all in the law, and it says if you cannot determine who it is, it doesn't make you exempt. On the contrary, now anybody who has a 25% interest in any class of shares, they all have to file as beneficial owners. So you see, the government is really, really inclusive when it comes to this 25% ownership interest, both wide and deep as to who is considered a beneficial owner. Who are the other filers? Somebody who exercises substantial control over the company. Now, what's called substantial control? It can be a senior officer, which means any CEO, CFO, CMO, CTO, anybody who has nobody on top of them reporting, or actually they'll report to the CTO, but these are decision makers, and they all need to be listed on the BOI. And general counsel as well is considered a substantial control, and the general counsel also has to be listed. Now, if you have authority to appoint or remove these officers, or, and that would be the board of directors or a single person, should he have the authority, he's also considered having substantial control. Or if you have a right to remove a majority of directors, that's also considered having substantial control. Government also says any important decision makers. That means if you're in charge of business structure, finance, marketing, any part of the business that you have decision making rights over, you're considered to have substantial control, and you need to be listed on the BOI. Now, there's one last group of people who have to be listed on the BOI, and they are the company applicants. So the company applicants are the person who forms the entity. So if you actually file the papers that form the entity, you're a company applicant and you have to be listed on the BOI. But it doesn't stop there. Assuming you have a clerk, let's say a lawyer, directs somebody to file the entity, to form the entity. So he asks his paralegal to actually draw up the documents, do the work, and form the entity. So since he's the one directing the formation, he would also have to be listed as a company applicant. So when it comes to company applicants, you don't necessarily have to have two people. It's possible that you only have one person who formed the entity. But in the case where one person is just doing the job and the other one is the one that directed it, then they both have to be listed. Now, there is one exception to company applicants. Company applicants have a few different rules. I'll tell you them now, and we'll see them more in detail later. The first one is that any entity that was formed before January 1st, 2024 does not need to list its company applicants. And I think that makes sense because you're talking about people who formed an entity and they didn't know what they were getting into. They were just forming the entity. And suddenly, January 1st, this new rule went into effect. So people don't want to be listed on the BOI. They don't want to be in any database. They don't want their residential address, their driver's license, their information, their date of birth. They'd rather avoid it. And in fact, there are many lawyers today that we speak to who used to do the formations themselves who now give it to us because they don't want to be listed as company applicants. So people want to avoid it. So when you form before 2024 and you weren't warned about this company applicant, the government says it's okay. You don't have to be listed. But any entity that was formed after January 1st, 2024 must list the company applicants. Okay, and we'll see the other differences. We'll see later when it comes to updating new information about, or if you have to update some of the information in the BOI, that only goes for the owners, the beneficial owners, and the ones that have substantial control. But if the person who formed your entity, you don't have to go track him down and find out if he changed his residential address and update the BOI. That wouldn't make a whole lot of sense. And it's great that they recognize that and exempted us. Okay, so a lot of times we have LLCs that are owners of other LLCs. And so the question is, do these LLCs have to be listed as beneficiary owners? So the general rule, which I want you to remember, and then we'll get into some more complicated scenario, is that the only people that have to be listed are people. The government is not interested in LLCs. They don't care about LLCs. They care about people that have an interest in the company, which means that assume that one LLC has 100% ownership of another LLC. On the BOI for the child LLC, you would not list the parent LLC. You would have to go back to the parent LLC, who has 25% ownership in the parent LLC, and then they're the ones that have 25% ownership interest in the child LLC, and therefore they would be listed as the beneficial owners. And the same thing with the control. If they control the LLC that controls the child LLC, they have substantial control, and their names and their details would have to be listed in it. So again, it's the people, not the companies. Now, let's take a case. This is actually a case from FinCEN. FinCEN gives this example, and I think it shows us exactly what's going on over here. So on top, you have the reporting company. Now, the reporting company is a joint venture, is 50% owned by Company Y and Company Z. So Company Y and Company Z do not have to file as beneficial owners because they're companies, they're not people. So Company Y is owned by A and B. A has a 30% interest and B has a 70% interest. Now, we're going to break this down into beneficial owners and substantial control. So first, we're going to look at this chart and just decide who has beneficial ownership interest. So on the face of it, individual A does not have beneficial interest because he owns 30% of the 50%, which means he falls short of 25% ownership of the reporting company. Individual B, who owns 70%, he is a beneficial owner because he ends up through Company Y owning more than 25% of the reporting company. Now let's look at the ownership of Company Z. Here comes individual A again. This is the same individual A as individual A from Company Y. So he's invested in both Y and Z. Now, although he only has 25% stock through Company Z, if you combine his two holdings of 30% and 20%, both in Company Y and Company Z, he turns 25% interest in the reporting company. So he would be considered a beneficial owner. So now you have A and B who both have to be listed on the beneficial ownership report. If you look at the rest of the owners of Company Z, that would be C, D, and E. None of them would have to file because they're not beneficial owners. They each own only 25% of Company Z, which leaves them with 12.5% of the reporting company, and therefore they're not considered beneficial owners. But now let's look at who has substantial control over the reporting company. So clearly individual A, he has control over the reporting company because he's the CFO. So he qualifies on both. It doesn't make a difference that he qualifies as beneficial owner and substantial control. As long as he qualifies as something, he needs to be listed. He only needs to be listed once, and he's going to be on the BOI. Individual B will be on because he's a beneficial owner. Individual C, although he does not a beneficial owner, he does have substantial control because he's the CEO and president. So D and E would be exempt, and you have individual F, who has direct important decisions through board representation. So he as well would be listed on the BOI. And if you look at the bottom, this is exactly what FinCEN is telling us. In this example, individuals A, B, C, and F are all beneficial owners. Is that clear to everybody? Any questions?
Okay, someone asked a question. How about Company Y and Z? Do they also have to file? I mean, the answer is yes.
So again, Company Y and Z are not people. Company Y and Z are companies. Companies do not have to file. It's the individuals that control the reporting company. We ignore all the middle layers called companies, and we look it's just between the reporting company and the individuals that have ownership rights within that reporting company. And that's why we look to the indirect owners.
Right, but you mean to say that you don't list a company Y or Z on the reports for the reporting company, which is all the way on top.
Correct.
But separately, Company Y and Company Z are also reporting companies, and they also need to file their ownership. That's what
Absolutely. They have to file individually. And in this case, everybody would have to file because if you look at the indirect owners, they're indirect owners of the reporting company. When it comes to company Y and Z, everybody on the bottom has a 25% ownership interest in company Y, in
Let me
company
see.
Y,
What
A and B, and in company Z, A, C, D, and E. Does that answer the question?
Yes, good.
Okay, great. Trusts. So today, any asset protection strategy has people set up with trusts. And the question is, what happens with a trust as a beneficial owner? So here it's different than LLC. And we don't look at 25% ownership interest. We have different criteria, and the government tells us six type of people that would have to file the BOI if a trust owned an LLC. Now, again, I want to make it clear: if a trust has a trust itself, does not have to file. So the trust does not have to file a BOI. But if a trust owns the LLC has to file a BOI. And the question is, if a trust owns more than 25% of the LLC, who from the trust is going to have to be listed on the BOI? Because as we said, the LLC itself is not listed and it's the owners. So who controls the trust is going to be considered beneficial owner of the reporting company, of the LLC. So we have trustee. He's the one that has, what does a trustee mean? He has to have authority to dispose the trust assets. He has to be a very strong trustee. He has to have full rights. Beneficiary. Now here, it's interesting. And I wondered about this, but it seems pretty clear in the law, and maybe you can check with your attorney or CPA. But if a beneficiary, let's say it's divided between two 50% beneficiaries, and that would make them 25% owners of the LLC. It would put them over the top for the LLC. They would not have to file, it seems, according to the law. A beneficiary only has to file if he's the sole permissible recipient of trust income and principal, or has the right to demand the distribution of or withdraw substantially all of the trust assets. So for some reason, when it comes to trust, this 25% rule goes out the window, and I'm not exactly sure why. It's like so hard for me to understand, which is why even though that's the rule, black and white, I don't feel comfortable saying it because it just doesn't. I can't wrap my head around it. Okay, number three, we have a settler who retains, or sometimes called a grantor, the one who creates the trust. If he retains, if it's a revocable trust, and he could take it back anytime he wants, so he really has full control of the trust, and therefore he has to be listed on the BOI. Now, again, all these people, it's not one or the other. Any of them would have to be listed. We have a trust protector who has, sometimes trusts have a trust protector, just, if people don't trust the trustee, and he has the authority to oversee and remove and replace a trustee. That means he has substantial control. I guess he would be the equivalent of an LLC, somebody who could remove members of the board of directors. If somebody is a distribution advisor, that means he has control over the trust money. So he has to file, he has to be listed. And same thing with investment advisor. He's the one responsible for the money in the trust, and therefore he is considered to have substantial control and would have to file as well. Okay, if that's clear, Ellie, let me know. If not, we'll go on to the next slide. There are filing exemptions. The law clearly states that certain people are exempt from filing, but like everything else that the law exempts us from, it's usually got a catch. So we'll start with the future inheritor. That's pretty clear. Just because you are written into somebody's will, it doesn't make right. Today, you have no control over the entity and you have no ownership interest, and therefore you are exempt. A minor, if a minor owns an LLC, and that could be done for a couple of reasons. Some people don't want to have a single member LLC, so they make their children, they give them an ownership interest. So if the minor owns the LLC, he does not have to be listed on the beneficial ownership interest report, but it's on the condition that one of his parents or custodian is listed. And as soon as the minor becomes of age, as soon as he reaches the age of majority, that minor needs to be listed as well. So the minor is not exempt. The minor personally is exempt, but his slot is reserved for somebody else. And if there is no somebody else, then the minor would have to be listed. Creditors. Now, creditors are an interesting question. Most of the time, a creditor is exempt from the BOI because the creditor does not own the property and he has no rights to the property. So the first question everybody asks is what happens if the creditor has a lien on the property? And the government says even if the creditor has a lien on the property, that's not considered ownership interest because what he has is a right to sell the property in order to get money. So all he really has is a monetary interest in the property or in the LLC and not anything else. And therefore, he doesn't have ownership interest in the LLC itself. He just wants to get his money back, and we just look at it what we have to do to get him his money back. So a lien does not make him a beneficial owner. Now, if the creditor can convert into shares or something like that, then clearly he becomes a beneficial owner because if you have convertible shares, you are a beneficial owner, as we discussed. Employee, I don't know why the government has to list that an employee is exempt. It's very clear. Either he's a substantial decision maker or he's one of the big titles, the C-suite or the general counsel. And if not, then by default, the employee is exempt. But the government lists employee as one of the 5 exemptions. And the last one is a custodian or a nominee. Now, again, the custodian nominee doesn't really have any control, just represents somebody. And again, the custodian nominee, since the custodian is representing somebody, the person he's representing would have to be listed in the BOI. So just like, some states let you have a nominee manager or something like that so you can avoid being public. It doesn't work with the BOI because we need to know who you are, and having a nominee doesn't help. The nominee is exempt, you are not. So the question is, what information is required?
Sorry,
Yeah.
let me stop you for a second. It's coming up with a few questions. So maybe speak about it. I don't know if it's on your slides. Who's
Okay.
responsible and liable to file this? And the question we keep having is, let's say an attorney gives their information, but the client or the owner filed the report and didn't list the attorney as the company applicant. Is the attorney's problem to fix that? Does he have any liability in general?
So it's my understanding that one person is responsible for filing, and you should check this. I can't say this with 100% clarity. I did come across this. I can't say it's completely clear to me that if I remember correctly, but there is one person, and that's part of the problem. The LLC has to file, but who are you holding responsible? That's a great question. It seems that one person is responsible. So who is going to be liable? Assume one person who needs to be filed refuses to give his information to the LLC or whoever is directing the filing. That person himself is going to be penalized. The other people will not be penalized. We'll get to the penalties, but just remember one thing about penalties. It's when you have willful intent. Um, and that's when the penalties kick in. That's clearly what the law says. I don't know if anybody would argue with me or say otherwise. I'm just telling you, I haven't heard or spoken to anybody about this, but the law clearly says you have to have willful intent. So it's going to be the one causing the trouble who's going to be responsible. So when you get to an LLC that just simply doesn't file, I guess they'll just go, the government will come to the LLC and maybe take the CEO or whoever they feel is holding back the filing. It's not clear. Or they'll say everybody's going to be responsible, or the LLC is responsible to pay the fine until somebody takes care of it. So I know I wasn't very clear, and that's probably because I don't have a very clear answer, and I'm not sure that there's a very clear answer to this question. So, like I said, ask, or if I will try to look into this more. Let me mark this down. I'll look into it, and then we'll try to update you, folks.
As far as if I could just Ellie Teitelbaum here, as far as I'm concerned, like you said, it is the owner's responsibility to file the report. They are at the end of the day the ones liable. Obviously the attorney should tell them about it, and that's why I've seen it almost in every email these days. Please note that your responsibility to file this report. But at the end of the day, the liability and the responsibility is on the owner, and it's the attorney's job to give them the information on whoever filed that, the company applicant, let's say the FinCEN ID or their information. But at the end of the day, the responsibility and the liability is on the owner or whoever in the company, like you said, did not give that information to file it, which would mean that the owner wants to file it, but he has to list someone and who doesn't want to give that information. It could be then that would be on that person. But as long as the attorney gives their information, they are not liable for not filing it.
Okay, great. Does that
And
answer
also,
the
we're getting
question?
a lot of people are asking for slides. Let me just say that we will send out all the slides. We'll try to do it to all the people that are attending. But feel free to reach out with an email, and we'll get it to you directly. Or if you have any questions, feel free to reach out.
Yeah, you can always reach out to me for any questions. You could find me on LinkedIn. That's probably the easiest place to find me. Um, yeah, okay. So you have to file two things. You have to file the reporting company itself. And for the reporting company, we need the legal name. We need any trade name or DBAs, the street address or the principal place of business, the jurisdiction of formation. So that would be the place where the state where the entity was formed, and the taxpayer identification number, typically an EIN for a company. When it comes to the beneficial owners, we need a legal name, a date of birth, residential address, and then we need a personal ID, which could be a passport or a driver's license, and we need an actual copy of the ID. Now, we're going to get to it in a minute about updating. Just note that when it comes to beneficial owners, there's two pieces of information that can change. That's your residential address. I mean, as much as we want to change our date of birth, we can never change that. That will stay the same. You can technically change your legal name, but that's not typical. Your residential address can change, and your personal ID can change. So keep that in mind. That's something that you're going to have to constantly keep updating the, the FinCEN with those details, and we'll talk about it in a slide or two. Okay, the filing deadlines. So any entity that was formed before 2024 has to file. Their deadline to file is January 1st, 2025. A lot of companies have started to file already, and there's always people like to get it over with quick, especially people with hundreds of companies. And then there's those who say, let's wait and see. In this case, the people who said, let's wait and see, were right, because we'll see that there is some issue about the constitutionality of the Corporate Transparency Act, and we'll share that with you in a topic at the end. If you filed in 2024, so originally the rule was that you would have to file within 30 days. But when the government realized that people don't really know what's going on and they themselves had to get all their systems in place, they relaxed the rules and said, if you filed in 2024, you have 90 days to file. So technically, nobody has had to file yet. There hasn't been a single deadline if you file January 2nd. So your deadline would be coming up in a couple of weeks. And we'll see what happens as far as enforcement is concerned. Everybody's got their eyes on FinCEN to see what's going to happen. 2025 and beyond, then we're going to go to what the rule was originally intended to be, and that means that you have 30 days to file. We typically, who we form entities all the time, we typically don't make a big issue with the CTA when it comes time to form an entity. We just add that as another filing that has to be done, and we encourage our clients to form the CTA together with their formation, because once you push it off, you can forget, and we'll see that it's not pleasant to forget. The penalties are not pleasant, and you don't want to wait 30 days or 88 days to file and just forget about it for whatever reason. So we try to handle it as not like this whole new thing by itself, but just a part of the LLC formation. So updating filings. Now, because you filed BOI, it doesn't mean that you have to file it once. That's great. The rule sounds fantastic. File it once and then you're done forever. It's not an annual filing, and that's fantastic. There's only one problem, that there are a couple of moving parts in the BOI. First of all, the company itself can have changes. The ownership can change. One person can become a 25% owner. Another person can no longer be a 25% owner. There could be a new DBA for the entity. An owner can die. There could be new decision makers. You hire a new CEO. You need to update the BOI. You have somebody who's a minor who now becomes of age, and he's now got to be listed. And here are the really problematic ones. I guess those issues go on the LLC. That's something the LLC has to be concerned with. But then there's the personal stuff. If you have a change, if you personally have a change of address, or you change your ID number, then you now have to go back. When you change to LLC, it's one LLC. So whatever happens to the LLC, you update the LLC and everything's great. But assuming you have 70 entities and you now changed your ID number or you moved, okay, business is good. You bought a mansion in the Hamptons and you moved. Now you've got to go back and you've got to change every LLC your beneficial ownership interest report because you're listed with the wrong residential address. So there is one very simple thing that you can do to avoid that. You'll still have to update it, but if you get there's something called a FinCEN ID, and it's a very useful thing to have. What you do is you file all your information with FinCEN, and then they give you an ID number. So what happens is that becomes you, and any LLC that you have a BOI that you report yourself in, you don't have to give all the pieces of information. All you have to do is just write down your FinCEN ID, and then that's called listing yourself in the BOI, which means if I have 250 entities and I change my address, I don't have to go back and update those 250 entities. I just have to update my FinCEN ID or my new address. And because my FinCEN ID doesn't change and it's listed in all 250 entities, I now was able to update 250 entities without changing a single BOI. So it's very important to have a FinCEN ID, especially if you have a lot of entities. It just makes the filing easier, and it will help you when it comes time to update. So for all these updates, you have 30 days to update. After that, you've passed your deadline. What happens, and I've had a lot of clients who tried filing their CTAs themselves, and then we started talking, and it turns out that they filed it inaccurately. So you have 30 days of after becoming aware that it was a mistake to correct your mistake. Now, the law also says that you won't be penalized for inaccurately filed reports corrected within 90 days. So I assume that's an original report. And I don't know how that jives together within the first 30 days. I mean, let's say you only find out 85 days later. Does that mean you have 25 days past the 90 days, or is 90 days a cutoff date regardless? Or let's say you find out on day 5. So you have 30 days, which would put you on day 35, but the government is not penalizing until 90 days. So to me, that's still a little bit, I don't have clarity over there when the deadline is, but I guess, I don't know. And we're talking about inaccuracies. So it's not something that you have a choice to file early or later. You can't file it before you find out that you've made a mistake. So that's something that we'll do further research into. Okay. What happens if you started an entity and first year you filed your BOI, and first year you were a smash success right out of the gate? You had $10 million in revenue and you hired already 30 people and you're exempt. So the first year you have a BOI because the previous year you didn't have $5 million in revenue since you're a new company in 2024. And now what do? Do you leave the filing and just leave everything alone and let it rot in the FinCEN database? So the answer is no. You have to go ahead and you have to update FinCEN that you're a newly exempt entity. Now, you may ask, why would I bother? I mean, you're not going to get penalized for, I don't think, I can't imagine you'll get penalized for not filing that you're exempt, but it does have one very clear ramification. And this is an important point. What happens when you have an exempt entity that has a 25% ownership interest in an LLC? And let's say you're the sole owner. So you have a 25% ownership you're 100% owner of an exempt entity, which has a 25% ownership interest in another LLC. What do? Do you have to file or not? So since your entity is exempt, you don't have the entity doesn't have to file, and we don't look up further and look at the owners of the exempt entity. What we do is on the BOI, we write the name as a beneficial owner, we write the exempt company name, and that's all that you have to do. Because again, the government already knows you because you have a large company, so they know who you are. Once they see the company, they don't need more information than that. They can always track you down. So therefore, exempt companies don't have to have their owners report in child companies, and they just write the exempt company name. Was that clear? Did everybody understand? Okay, great. Penalties. So the penalty for not filing is up to $500 a day, and that goes until $10,000. You max out at $10,000, but just remember that you max out after 20 days, and that happens pretty quickly. And you also have potential 2 years of jail time if you willfully, with intent, don't file or hide information or inaccurately file your BOI. So the government is serious about this. Like I said, still interested in seeing how they're going to enforce it and how seriously they're going to enforce it. That will take some time until we see that. Okay, now here comes the big bombshell that all of you folks probably heard about already. 2 weeks ago on Friday, March 1st, the U.S. District Court for the Northern District of Alabama stated the Corporate Transparency Act is unconstitutional because it cannot be justified as an exercise of Congress's enumerated powers. So my first reaction when I saw that decision was, and I read the decision, it's 53 pages long and pretty harsh. That's when I should have known that something was up. It was like, okay, so FinCEN is going to have to announce that they're stopping to enforce the CTA until they can appeal. We know that they're going to appeal this, but in the meantime, it was declared unconstitutional. So let me just, for those of you who are not lawyers, let me explain to you what this means. When a state court, and this is the problem with LLCs are state laws. So if New York has a ruling on LLCs, it has nothing to do with Delaware or Texas or Illinois because it's only state law. And no other court in any other state has to even look at that ruling and take it into consideration. When it comes to district courts, it's true that this is the Northern District of Alabama. And a California district court is not bound by the ruling of the district court, but it is persuasive. It must take into account any other court, any other federal court that is going to rule on must take into account that the Alabama court already ruled it unconstitutional. They can disagree, but it does carry weight that the district court said it's unconstitutional. It carries weight across the whole federal court system. So I would have expected, because of that, FinCEN would announce that they're not going to enforce it until they appeal it. But FinCEN boldly got up and said that they will continue to enforce it. Let's go into the ruling a little bit deeper. So the ruling was by a U.S. District Court. We explained what that means. And it was in the Northern District of Alabama. Now, that's one of the more conservative areas. And conservative areas, we know, like to limit the federal powers. So whereas the judge was really harsh, what the judge basically said was that there are no powers in the federal government that allow it to interfere and make businesses file a report to give them information. So just so you know, a state has no problem doing the same thing. And New York already enacted a law that will be the same as the CTA. But can the federal government do it? No, they're too far removed from any interest that the Constitution gives them. So, but that's how the Northern District of Alabama read it. It's very easy to read the decision and understand that a less conservative, a more liberal court would definitely see things otherwise. So we know that this, if it's brought up in more liberal, let me give you a little bit more background. Look at number 4. The plaintiffs were the 60,000 members of the National Small Business Association. So they could have brought this lawsuit anywhere in the country because they have members in every state in the country. They specifically chose to file their lawsuit in the Northern District of Alabama, obviously because they thought that's the place where they have the best chance of winning. So they won there, but they probably would not win in many other districts. So on one hand, we know that this is probably not going to be the majority of the court opinions. On the other hand, the judge's ruling, while it was very harsh against the government, it was a very narrow decision. He didn't rule it unconstitutional and say it cannot be enforced at all because it's unconstitutional. He played semantics and he said it can't be enforced against the plaintiffs. So that means while he feels it's unconstitutional, he only enjoined FinCEN from enforcing the rule against members of the NSBA. And anybody who's not a member of the NSBA will still have to file. And that's exactly what FinCEN said 3 days later. They came out and they said, okay, we will respect the ruling. They don't have a choice. And we will not enforce it against the plaintiffs, any member of the NSBA, as of March 1st. So if you're thinking about running to become a member of the NSBA, it's a little bit too late for that. But everybody else should continue filing because we will be enforcing it against you. So that's the first thing they said. The second thing they said is that they will appeal the ruling. Now, the question is, what happens even if the ruling is upheld, because they're going to appeal it to the 11th Circuit of the Court of Appeals, which is also very conservative because that's the district, that's the circuit that is on top of Alabama, and they may win in the Court of Appeals, but probably there'll be lawsuits all over the country, and we can expect to see this other districts saying that it's constitutional. So what typically will happen in that case, because this is the federal system and it should be unified, it will end up going to the Supreme Court. But until it gets there, it's going to be a while, which means that we can expect to have to continue filing for the foreseeable future our BOIs, unless another ruling says not. But until there's another ruling, until anybody else other than NSBA is going to have a court ruling for FinCEN to take their fangs off for them and stop enforcing it. Okay, so we said what could happen next? Lawsuits against the CTA in other states, government appeal to the Court of Appeals 11th Circuit, and then there'll be split rulings, and then it will go all the way to the Supreme Court, which again, until it weaves its way and winds its way through the court system to get to the Supreme Court, should be a while. I assume that at the end of the day, it's not going to be clearly unconstitutional, even if it is. I mean, either FinCEN will win and will stay as is, or the other choice is that they'll have to modify the law to just smooth the round edge, to round the sharp edges and make it constitutional. The other wild card is that FinCEN really doesn't even have to have this law, because they actually do have to have the law, but New York State has come up with their own Corporate Transparency Act, which is going to require all this information anyway. And California is now, the legislature is now thinking about enforcing it. I just read today that another state is enforcing it. This is going to have a wave effect throughout the country. And I assume that most of the states, or a good portion of them, are going to have their own CTA. So at the end of the day, just understand one thing about the CTA. While it's going to cost you not a lot of money to file it, it's not a terrible thing. It really is just for law enforcement and all you folks who are running legal businesses that are not involved in law enforcement and drugs and money laundering have nothing to worry about. The information stays in a federal database, cannot be accessed. There are rules to how to access it. And if you think the fines are heavy for those who don't file the CTA, the fines for leaking this information or getting it illegally are much heavier. So you're really not in any danger by filing the CTA. So I think it's okay to file the CTAs from that perspective. You'll still have, for those of you who have set up LLCs in structures that you have anonymity, you will still have the anonymity that you're looking for asset protection. Nobody will know what you own. And really, it's not a big deal, the CTA, as far as I'm concerned. So whatever happens, I think there will be a CTA at the end of the day, and it's okay to have a CTA at the end of the day. Okay, so a little plug for us. How can we help you? We have expert assistance with the LLC, with any LLCs, structuring and forming them, and the CTA. If you want to reach out and you have any questions, how to file, or if you'd like us to file for you. We have a very user-friendly LLC portal to keep all your filings and documents organized and compliant. And it's got a dashboard. It's really pretty cool. This is Elliot's brainchild. He's worked on it, and I've done lots of demos with him. And people who were very happy with how their LLCs are managed are fleeing to us. Really, when they see the demo, they love it. You can keep your documents there. It sends out emails reminding you. You can pay annual fees through them. You can take care of a registered agent. We have it for our clients, but we also have a service that lets you use our portal even if we're not forming your LLCs and we're not your registered agent and not handling your annual reports. It's okay. You can use our portal, and especially for the CTAs. So like for the CTAs, we can see if your document, let's say your driver's license is or your passport is expired, you'll get an email from us letting you know that your CTA no longer is in service and or has to be updated. You can see all the people in your CTA. You can use them to easily file new BOIs because you could just like check off which people have to be listed in your BOI. It's really quite impressive. Congratulations, Elliot. Well done. So that's 3. And of course, we're registered agent service in all 50 states. Our service runs across anywhere you would need it. So it's uniform and unified and easy to use. Okay, I think that wraps it up. Elliot, if there are any more questions or if somebody wants to ask a question now.
Yeah, I think you should open up for questions, but let me just ask say one question that I did find in the questions a few times, which has to do with company applicants. So just like beneficial owners, company applicants are an individual, not a company. So even if you hired a company like Riverside Filings to file your entity with the state, so the company applicant is not Riverside Filings, it is someone that works at Riverside Filings, an individual like Ellie Teitelbaum. So
Right,
I would have to provide you my FinCEN ID, my information, and even if I leave
absolutely.
Riverside Filings, I would still need to be the one listed as the company applicant. It's not the company; it's the individual.
It's the individual, and if you move, nobody has to know about it. You don't have to update it. You can. They just want to know. It's not an ongoing thing. That's just a one-time thing. They want to know who formed the entity, and it doesn't make a difference what happens thereafter. They understand that the applicant is not necessarily connected to the company, but if they ever have to go back and they want to know something about the formation, that's the person that they would want. So, yeah,
I will say, I guess, one more thing. I'm actually not sure if this was on the slide, maybe by mistake, but the company applicants are not needed for anything formed before 2024. Only for things
correct.
formed after 2024. And another question that just came in from Daniel is, does a CFO with no ownership interest have to report or be reported? I guess is the
Absolutely. He's considered to have substantial control. Any CFO, CTO, any C-suite executive has to be listed on the BOI as well as the general counsel. And then there's the more amorphous, there's a catch-all phrase that says anybody who has any decision-making ability. So that's a little bit tricky. What that means, nobody really knows because they're pretty detailed about all the people that do have substantial control. But again, they're basically telling you this is a wide net. And if you have any doubt, just list the person.
If anybody has any questions, I guess now would be the time to ask, or feel free to either email Tzvi or myself, and we'll be glad to help out. People asking now about the portal. Obviously, the best way to find out more, we'll be glad to do a portal demo with you. It takes less than 20 minutes. It's an easy-to-use, user-friendly portal. So feel free to email us and reach out for a demo as well. Maybe you want to just skim through the questions if you could see the chat and see if you want to answer them directly before starting to post.
Gentlemen, can you provide us with your email addresses?
Sure. I'm TWEISER, as in T Weiser, at rsfilings.com. And Elliot, you want to spell your email address so I don't make a mistake?
I'll do it. I'm going to put it into the comments right now. See why.
Oh, okay, great. Okay, I see somebody, Robin Greenstein asked, is the portal for all entity types? And yes, can we create accounts for the client directly and add access as needed? Elliot, I think they can. You want to just address that?
Sorry, say it again. Yes, I think I responded to that. Yes, we obviously we manage all entity types, and yes, we could. There's a few ways of managing access. It could be billing the client to your account, making his account, and giving you access. So there's a lot of it's a little dynamic, and like you said, we could set up a portal and discuss it. Demo, sorry, to be clear.
I have two quick questions. If I filed it, but I forgot to request my Fin ID, is there a way to get it, or do I refile it? Or if I file for a second entity, will it automatically connect it? How do I go about that?
That is a good
So
question. Go ahead, see.
This is your expertise, but you're smiling, so I'll try to answer it. You can filing a FinCEN ID is not connected to the BOI. You can file it for a FinCEN ID anytime you want. For any entity that you filed a FinCEN ID, I think that would be okay. But I would guess if you didn't have the FinCEN ID at the time that you filed your BOI and just listed the information, you should probably update it with your FinCEN ID because I would assume that you would have to update it because it has incorrect information. And you can't expect the government to go back and track your FinCEN ID from your name. What do you say, Elliot?
Correct. I would just say if you did create yourself a FinCEN ID, they're not going to track it, but there's no phone number for FinCEN, but there is you could request for help on their website. And the best thing to do would be to ask them for help. They take about 2 weeks or so to enter, and they should be able to get you your FinCEN ID. I hope so. Honestly, I don't know how they identify you to know to give you your FinCEN ID or not yet. Um,
But is it automatically created? Like when I
It's
file?
not automatically created. No, no, no. People are making that mistake. Actually, I'm finding accountants and things making that mistake. It is not automatically created, and which means that
You have to check that box.
no, checking the box provides a FinCEN ID for the entity. It doesn't create a FinCEN ID for the person. It's a separate application to apply for a FinCEN ID for the person. People are making that mistake. They think that box is asking for a FinCEN ID. That checkbox when you're filing a BOIR is just for a FinCEN ID on the entity, which is very rarely needed. There's like one scenario where you could list another entity as the BOIR for another entity.
Yeah, if it's exempt, if it becomes an exempt entity, so you would list
right.
it there. Right.
Exactly, but otherwise, you have to do a separate application for a FinCEN ID on the individual, and then you use that ID as you file the report.
So you file the individual as the entity.
No, it's a separate application, a separate link. I could send you the link if you ask us afterwards. You can search online. It's a FinCEN ID link. You have to create an account with I forgot what it is, gov, something.gov, and you create a separate account, basically with the Department of Revenue.
Okay, understood. Thank you.
No problem. There's no living employee. Again, people asking about the company applicant, I will just bring up because I don't know if people here are attorneys or accountants, but yes, you do have to know that if you're filing for people, we have a few times accountants or attorneys telling us, but we don't want to be the applicant. You're going to have to work on your order system if you're directing the application or you're inputting the application into the New York State system, even if you list the actual filer as the owner of the company, if you press that button, you are the company applicant, and you as an individual have to be listed, not the company.
I want to ask a question. So, say I file for an LLC that has a number of beneficial owners that are listed. How do I keep up with changes that they make in their life, like changing their address, or they lose their driver's license, get a new driver's license that has a different number on it?
So I just want to make one point that me and Elliot were discussing yesterday. When you change your driver's license, you usually have the same number. It's the same driver's license number.
But let you lose it, because it happened to me recently.
Right. And you got the same number?
Got a different, they changed my number.
Oh, so if they change the number, you certainly have to update it. But if they don't change your number, it seems
It's
from the
state
law.
specific. Some states change the numbers and some don't. It looks like, yeah.
So if they don't change the number, it seems that you don't have to update the system, even though you have a copy of an invalid driver's license because it's expired. But again, from what I read from the law, as long as the number stays the same, you don't have to update it. But in general, yes, you do have to keep track of all the BOIs, all the beneficial owners, and update it every time they move. It's not a simple process, which is why you should encourage all of them to get FinCEN IDs. Now, either way, if there are changes in the company, you're going to have to update it because there could be different beneficial owners. But at least you won't have to change the information within the beneficial owners because of that. These are people you may not be in touch with, so it's hard. It's not an easy process.
See, someone's asking about a C-suite. If you want to see the last question.
Okay. Yes, so the question is, if you have a holding company, just for everybody else, if you have a holding company and it has a CEO, and there are a whole bunch of different properties, and it's controlled by the holding company. So the CEO of the holding company has substantial control of each one of the uh, properties of each one of the child LLCs, and therefore he would have to be listed on every BOI.
Someone
Okay.
asked about disregarded entities now. So yes, to file the BOIR, you do need to get an EIN on disregarded entities. You know, it used to be single member disregarded entities didn't need EINs. But in order to file the BOIR, you do need an EIN because every BOIR is tracked by the EIN. So you can't use a parent EIN or anyone's social. You would need to get an EIN on disregarded entities now.
Hi, can I ask a question? What if
Sure.
a revocable living trust is, do they need to, are they a reporting company?
So the trust itself is not a reporting company, but the trust can be a beneficial owner if there's an LLC within the trust. And
Okay.
if it's revocable, so the grantor, the one who created the trust, would be considered, have to be listed on the LLC's BOI.
Okay, so if it does not have an LLC owner, then there's
The
no,
trust, yeah,
right, because
the
they're
trust itself
reporting
doesn't
on
need a file.
individually, right? Okay. Okay, thank you.
Sure.
Okay, I think we'll wrap it up. Tzvi, you want to make a closing statement?
Look, we're in flux now to see what happens with the BOI. We're telling clients that if you form an entity today, you should file your BOI. You don't have to wait till the end of the 90 days because probably not much is going to change. If you want to, you could. But those who have entities from before 2024, there's no rush to file. You can revisit it after the summer, see what happens in the summer, September, come back. You'll have plenty of time. Don't wait till December because it's going to be hard to file LLCs in December. And we'll get an idea where the winds are blowing by the time we get close to the fourth quarter. Okay.
Okay, thank you everyone for attending. And again, if you have any questions, feel free to email myself or Tzvi. I put our emails into the chat, and we'll send out an email afterwards with our information as well to everyone that attended. And we hope you enjoyed.
Thank you, everybody. I hope you learned something. And if you have any further questions or if I was not clear on something that you'd like to understand, you can reach out to me personally. I'm very happy to talk to anybody on an individual basis anytime. Thank you and have a great day.